Good afternoon. This webinar offers closed captioning. To enable closed captioning, click on the live transcript button on the bottom of your screen and choose your preferred method. Welcome to the City of Chicago's Department of Business Affairs and Consumer Protections webinar. We have adapted our regular business education workshops at City Hall into these webinars until further notice. Please note any website or email that I mention will be posted in the chat box. For those seeking business licensing assistance, we strongly encourage the processing of license and permits online. Business licenses can be applied for or renewed online at chicagobusinessdirect.org, or you can call 312-74-GO-BIZ. If you're part of the BACP Entrepreneur Certificate Program, you can get credit for joining this webinar by sending an email to bacpoutreach@cityofchicago.org. If you want to learn more about this program, please visit chicago.gov/businesseducation. Also, this webinar is being recorded and will be available at youtube.com/ChicagoBACP. I will post the mentioned information in the chat box. We encourage attendees to ask questions. Please use the chat box to send these questions. There will be a Q&A session at the end of the presentation. Please note that the views, information, and opinions expressed during this webinar are solely those of the presenter and do not necessarily represent the official policy or position of the Department of Business Affairs and Consumer Protections or the City of Chicago. Today's webinar will be when to set up an entity and entity choices, presented by the Pritzker Entrepreneurship Law Center and Northwestern Pritzker School of Law. Esther, Darren, feel free to start whenever you are ready.
Hi, everyone. Thank you so much for joining us. I'm Esther. Darren, do you want to say hi?
Hello, I'm Darren Graydon. Nice to meet everyone, sort of.
And we're both faculty as mentioned, in the Donald Pritzker Entrepreneurship Law Center at Northwestern Law School. And we're, again, very excited to be here talking about when to form an entity and some thoughts on maybe which entity to choose. I'm going to start by talking about when to form an entity and why timing is important. And then Darren's going to go into some of the different popular choices that entrepreneurs and small business owners often will consider when they're actually forming the entity. But I'm going to start with a really basic question. Why do we care? Why even form an entity? And what happens if you don't? If you're running a business by yourself and you haven't formed an entity, you haven't filed any documents with the Secretary of State actually creating an entity, and again, if you're running the business on your own, you are a sole proprietorship. By default, you don't have to do anything extra. You are automatically a sole proprietorship. If you are running a business with somebody else, you are, again, without taking any other actions or even deciding that this is, the way you want to go, you are by default automatically a general partnership. In Illinois, as in other states, the definition of a general partnership is when any two or more people come together to run a business for profit. So if you're, selling T-shirts with somebody else, then you're running a general partnership. If you're running a bakery with somebody else, you're a general partnership. Again, and that's without making any decision or electing to be a general partnership. It actually happens automatically. And so you might say, well, great, it's automatic, so I guess I don't have to do anything. And that's true. But the problem with both of these types of businesses, sole proprietorships and general partnerships, is that they both have unlimited personal liability for the owners. So if you're, again, running the business by yourself and you're a sole proprietor, or you're running it with someone else or more than one person and you're running a general partnership, you as the sole proprietor or partner have unlimited personal liability for debts or obligations or damages that may be against the business. And what that means is that third parties who have claims against the business have claims against you personally, or at least against your assets. So there's no protection of your personal assets or separation of your personal assets from the business. So if someone were to breach a contract or sell a defective product and someone sues the business for those damages, your own personal assets are exposed. Your bank accounts, your money, your whatever you have, whatever your assets are exposed. So many times that's, obviously unattractive to people. And so that's one of the main reasons why people will take the step of actually selecting an entity form and going to the trouble of setting up an entity. And when I say going to the trouble, it's really not that much trouble. And Darren's going to talk a little bit about that. But that's one of the main reasons why we find sole proprietorships and general partnerships unattractive, and a reason why we generally encourage our clients to go ahead and set up an entity. Sometimes people will ask about timing. Well, when do I set up the entity? And there's no magic answer to that, but it's really once your business starts doing anything that could create liability. And sometimes people will underestimate liability. Oh, well, my business is, it's not like we're selling fireworks. It's, we have a consulting service. Well, really, you want to be very honest with yourself about what could create liability. A breach of contract, and an unhappy customer, an unhappy employee. So again, there's no magic answer, exact right time when you should set up an entity. But some of the red flags that we will suggest to our clients to think about as timing for setting up an entity are you selling anything? Are you, whether it's a product or a service? Have you hired anyone? Do you have employees or people working for your business? Are you signing contracts? Are you borrowing money? Are you selling equity? These are all really good flags and indicators that probably you should consider setting up an entity. We'll also get the question of, well, I get it, that makes sense, but if something bad happens, then we'll set up the entity then. Like, we'll wait and see. As long as things are going kind of smoothly, we don't feel the need. And the problem with that strategy is that once something does go wrong, or once liability is created, you can still set up an entity that's correct, but any liability that was created prior to the entity being set up is personal. You can't fix that by setting up the entity. So any liability that's existing when you set up your entity is going to be the personal liability of either the sole proprietor or the general partners. And one thing that I want to add that makes it even riskier when it's a general partnership as opposed to a sole proprietorship. Again, they both have this unattractive quality of having unlimited personal liability. It's even riskier with a general partnership because at least with a sole proprietorship, you at least have some control. If you've done something, if you've signed a contract or sold a product or service or signed a lease or taken on a loan, all these things, if you've done. Once you go into business with someone else, even someone that you trust and is very honest, you don't always know exactly what they're doing. They maybe have great intentions, but may sign a contract without telling you, or they may be on the way to a business meeting and get in a car accident. So there's additional risk because it's not just actions that you take that you could have a liability for. Now you have this potential liability from any of the actions your partner or partners take. So again, these are not options that we recommend. Once you're actually running a business and doing some of the things I mentioned, like selling either a product or service, hiring employees, signing contracts, taking on debt or equity or selling equity, it's a really good time to think about setting up an actual entity. Most of the clients that we work with, there's lots of different options out there, tend to narrow it down to a corporation or an LLC. Again, there are other options, but those are the typical choices that we see. And I'm going to pass it over to Darren, who's going to talk in more detail about those specific options. Thank you.
Thank you, Esther. As Esther mentioned, there's lots of good reasons to set up an entity, usually fairly early in the process, right? So putting up that liability shield around yourselves, not allowing you and your sort of partners or co-founders to default into a general partnership structure, right? Which is not a positive development, as Esther mentioned. Usually reasonably early in the process, it's a good idea to get an entity set up. Sometimes entrepreneurs or founders will delay it, right? And one of the reasons they'll delay it is there's sort of a thought that, well, this is going to be complicated. It's going to be expensive. Let's just kind of kick the can down the road. We'll do it some other time. We'll do it later once we know we've sort of got a business. So I'm going to be talking about sort of the process to form an entity and choice of entity. But one thing I want to mention sort of right up front, the act of forming an entity, actually creating that entity to get away from the risk of the general partnership that Esther talked about, is actually quite easy. So every state in the country allows you to form an entity in that state. And, in Illinois, for example, it's a very simple process to form an entity. The Secretary of State here makes most of this available online at their website. And it's you provide, 2, 3, 4 pieces of information. That's it. There's a very reasonable filing fee. It's not a high filing fee relative to other states. And you can submit it right online, and there you go. It's one-page document, and anywhere from a day to a couple of weeks later, you'll have your entity. So creating the entity itself is just filing what they call a certificate of incorporation or articles of incorporation, if it's a corporation, articles of organization, if it's an LLC. That's very easy and not all that expensive. What tends to be a little bit more complicated is if you're going to have other owners of the business besides yourself, co-founders, partners, then you'll typically draft agreements to sort of define that relationship between all the owners, right? If there's 3 owners or 4 owners, you're going to want some sort of agreement, a shareholders agreement or whatever it's going to be called, to determine how decisions are going to be made and things of that nature. Those things don't get filed with the state. Those are agreements that are sort of internal to the group of founders and can be done sort of after you form the entity. You can work on some of those agreements. There's no filing fee for those agreements. There are things that you just need to put together and sign. So that I want to sort of cover that right up front, that the fear of sort of the expensive headache-inducing entity creation process is not all that bad typically. It's not all that hard to do. All right, so we know we want an entity early. We know it's not that hard to form the entity itself, not that expensive to form the entity itself, certainly not in Illinois. It's pretty easy and inexpensive. So the next question, of course, is what should we form? There's no one answer to this question. You could talk to a group of different attorneys or folks that have started businesses before, and you'd probably get a bunch of different answers depending on what it is you're going to be doing. What are your plans? It's not one size fits all. So let's talk about a few of the choices. And Esther mentioned 2 of the most popular choices. And those choices are what we call a C corporation. A C corporation is kind of the standard default corporation. When you form a corporation in any state, including Illinois, you sort of start out as what they call a C corporation. There's another type of corporation that I'll touch on in a moment briefly, because you'll hear the term out there, called an S corporation, which we'll come back to in a moment. The other choice that Esther mentioned was a limited liability company or an LLC. The vast majority of early stage businesses that are launched by entrepreneurs are started as either C corporations, S corporations, or limited liability companies. And really, C corporations and limited liability companies are probably the most popular these days. So let's talk a little about what each of them offer. So C corporation, that's the oldest structure. It's been around for a long time. It's one of the earliest structures that was available here in the United States. Most of the big companies that you might read about in the news, companies that are raising lots of money, companies that are going public, Google and Facebook and all the big names that you see out there, C corporation tends to be the most popular structure for those types of businesses. The benefits of a C corporation, there's a number of benefits to forming a C corporation. One is you get that liability protection, that shield of liability around the owners of the business that Esther mentioned during her talk. So if you form a corporation and you're an owner, called a shareholder in a corporation, you've got liability protection. So if something goes wrong, you make a mistake, somebody makes a promise on behalf of the company that can't be fulfilled, Whoever feels wronged, if they decide they're going to initiate legal action, file a lawsuit, they can go after the company, the entity, the corporation, but not each of the individual owners. That's the liability shield that you put up around yourselves, which is one of the principal reasons, as Esther mentioned, in forming an entity in the first place. So C corporations work well for that. There's a long established body of law protecting the owners of corporations. There's limited exceptions where somebody can try to find their way through and sue an owner directly, but it's hard. It's not easy to do. And if you sort of act like a corporation, you form a corporation properly, and you sort of follow the corporation rules in Illinois, if you're formed in Illinois, you're generally good and protected. So liability protection is one benefit. There's also some flexibility with C corporations. And by that I mean, you can issue any kind of stock you want. So typically the owners in a corporation own stock. So if you and a partner form a corporation, each of you would own some number of shares of stock to sort of evidence your ownership, how much you own in the corporation. You can get creative with the types of stock you issue. So for example, if you were going to raise money from investors, sometimes investors want a different kind of stock, a better stock than the founders got. So you may have heard the term preferred stock and common stock. So when you form a corporation, you typically issue to the founders, the initial owners, common stock, which is sort of plain basic stock. Investors want something better. They're giving you money. And for that money, they want certain special rights. And we won't get into what all those rights are, but they need a different type of stock to get those rights. And corporations can issue that type of stock, preferred stock. So that's one of the reasons corporations are popular choices for companies that are going to raise money. Some of those corporations I mentioned, like Google and Facebook, that back in the day raised lots of money as they were growing initially, being a corporation was helpful to them in raising that money. So that's one way we have flexibility in terms of what the corporation issues to the owners. There's other flexibility. Anyone can be an owner in a C corporation, meaning an individual can be an owner. Another corporation or another LLC or some other type of entity can be an owner of a C corporation. Owners can reside anywhere. They can be in the United States. They can live in a different country. There's no restrictions around where an owner needs to be. There's no limitations to within the United States. So there's flexibility there. You can have any number of shareholders or owners. So you can sort of do what you want, staying within the general rules of the state of Illinois, if you're in Illinois, or a different state if you're formed in a different state. So those are all positive things. And all of those reasons are sort of behind the popularity of corporations. But corporations aren't perfect. No entity is perfect. There are some drawbacks, and we won't get too deeply into taxes. We run the other way when we get too deeply into taxes, but we will mention them because they're always relevant when you form a new entity. You always have to be thinking at least a little bit, which usually means working with your accountant to make sure you're not creating taxes where you don't want them. So corporations have something called the double taxation. You may have heard that term before. So at a very general level, if the corporation makes money each year, and hopefully it will, the IRS, the Internal Revenue Service, looks at that corporation and treats it like sort of a fictional person. Even though it's not a real person, it's an entity, they sort of view it as a person. And if that corporation makes money, the IRS will tax that corporation based on the profits that they earned. So that's not shocking. Corporations pay taxes. That is to be expected. So they write the IRS a check for their taxes, and that's one single taxation. But let's say the corporation has a good year and it's sitting on some money at the end of the year. The corporation can do anything it wants with that money. It can reinvest it in the business. But another thing it can do, it can decide, we, the corporation, don't need all this money. We're going to return some of this money to our shareholders, to our stockholders, to our owners. And you do that by declaring a dividend, right? Dividends are generally good things. The corporation sort of giving money to the shareholders. Problem in a C corporation is if you declare a dividend and pay money to your shareholders, the IRS taxes that too. So that's the second layer of taxation. They first taxed the corporation on the profits it earned. Then they taxed the owners, the shareholders, on dividends that they received from the corporation. So that's called double taxation. In essence, the IRS is taxing $1 twice rather than once. And so again, at a very general level, getting taxed once is preferable to getting taxed twice. We don't want to be taxed a bunch of times. So that's something that you'll sort of hear out there, double taxation being a drawback for C corporations. So because of that, founders and entrepreneurs were sometimes hesitant to form a C corporation because they talked to their accountant and their accountant sort of explained some of the tax drawbacks to being a C corporation, which sometimes led the accountant to suggest a different type of corporation, which I mentioned before. So when you start as a C corporation, there's a second filing you can make with the IRS. It's called an S election. And you're basically telling the IRS, now I want to be an S corporation rather than a C corporation. So what's the difference besides the difference in letters that we use to associate with each type of corporation? An S corporation is just like a C corporation. You have shareholders, you have liability protection, you have all of those benefits, but you get one added benefit. S corporations don't have double taxation. The idea is that the IRS typically, there's exceptions, but by and large, they're not going to tax that corporation like a fictional person. They're going to disregard or ignore that corporation. They're not going to tax its profits. Instead, they're going to tax just the owners, the shareholders, one time on the profits. So there'll be single taxation on the dollars earned by the corporation rather than two taxes, a tax on the profits and a tax on the dividend if a dividend is declared. So in many ways, S corporations are kind of the best of both worlds. You get the liability protection, you get what they call single layer taxation rather than double layer taxation. The problem is, and the reason that S corporations aren't quite as popular is that there are restrictions. All of those different sort of flexibility attributes we talked about with C corporations, many of them don't exist with S corporations. For example, there's limitations on the number of shareholders you can have in an S corporation. It's changed over the years. I think it's settled in right around 100 now. So that's still a big number for most companies. You're probably not going to have 100 owners. So maybe that one's not problematic. But there's other restrictions. For example, only an individual can own shares in an S corporation. So if another owner wanted to own their shares in an entity, another LLC or a C corporation or any type of corporation, by and large, they can't do it. It's got to be an individual. So that restricts who can own shares in an S corporation. I mentioned how investors want a certain type of shares, preferred shares, kind of better than common shares. You can't issue preferred shares in an S corporation. There's a restriction, there's a limitation. You can only issue one class of stock, common stock, that's it. So if you were going to raise money from bigger investors, if that was part of your business plan, an S corporation generally isn't going to work. Shareholders have to be sort of US nationals. With limited exceptions, you can't have shareholders outside of the United States. So if you were going to have a shareholder, in Mexico or Canada or somewhere else, can't do it. So because of all those restrictions, entrepreneurs, folks that are starting businesses, are often hesitant to use the S corporation structure because it's too limiting. There's too many rules around it. So C corporations are good, but there's some tax inefficiencies we talked about. S corporations take care of the tax problem, but create their own set of issues with all the restrictions, which leads us to the third type of entity that Esther mentioned before, which is a limited liability company or LLC. So LLCs, in theory, are kind of the best of both worlds. It's as if you took the best of a C corporation, the best of an S corporation, and sort of brought them together and mixed them together in a pot, a greatest hits of all the entities. So LLCs have the same liability shield that we talked about for C corporations. So if you form an LLC and you're the owner of an LLC, in LLCs, they're called members rather than shareholders, but it's the same thing. It just means that you own a piece of the business. Someone who's upset, a creditor or someone you've done business with, if they're upset, they should only be able to go after the limited liability company and the assets owned by the limited liability company. They should not be able to go after any of the owners or members personally. So that's the first thing we get with an LLC, the same liability protection we got with a C corporation or an S corporation. LLCs, like a C corporation, have all sorts of flexibility, meaning I can have any number of owners. The owners can reside anywhere. They can be individuals or other entities. So all of those S corporation restrictions go away. They can issue different classes of equity. They're called membership interests or units typically, rather than stock. Same thing though. So I can issue preferred membership interests if I had an investor coming in. So it gets rid of a lot of those issues that we talked about with S corporations. And best of all, it's also what they call a disregarded entity or a flow-through entity, meaning it's taxed like an S corporation, single taxation versus double taxation. So we're getting the good tax treatment of an S corporation, the good flexibility of a C corporation, the liability protection of both, all in one entity. So limited liability companies are very popular choices these days. I'd say the businesses that Esther and I work with, maybe even the majority, I'd say, are limited liability companies. And again, forming a limited liability company in Illinois is quite easy. Illinois asks for just a couple of pieces of information. It's a very simple filing. And again, as it relates to Illinois, you make an annual filing each year whenever you form an entity. Illinois makes that easy as well. You can do a very simple annual filing. Shouldn't take more than a couple of minutes, and it's not that expensive. So LLCs tend to be good choices based on their flexibility that they offer, some favorable tax treatment. Something to be aware of though, they're not the perfect choice because there is no perfect choice. You sort of have to look at your situation and decide which one makes the most sense for you. If your plan was to raise money, and we talked about this a little bit before, if your plan was to raise money from big investors like venture capital funds, if your business required $2 million of investment, really big investment, those types of investors sometimes have restrictions on their end in the types of entities that they can invest into. We won't go into detail into those restrictions because they get sort of knee deep into taxes, which we like not to do. But suffice it to say that some of those professional investors are only comfortable and able to invest in C corporations. So in a situation where your business plan called for raising lots and lots of money, that would be something you'd want to think about, that, well, maybe we're going to need to be a C corporation. The other time you think about being a C corporation, you've probably seen, or some of you may be familiar with, all of the different, what they call accelerator programs across the country. There's some out west, there's a bunch in Chicago, like Techstars and many others, there's plenty out east. These are programs where early stage businesses and entrepreneurs will sort of go through some sort of mentoring over like a 90-day period to sort of grow their business, and maybe they'll raise a little bit of money at the end of that program. If that was your plan, if you were thinking, I want to go through one of these accelerator programs, you apply and you have to get accepted. Some of them require you to be a C corporation. So if that was in the cards for you, you'd want to look at the rules. They post their rules typically online just to see if there's a certain type of entity you need to be. But most entrepreneurs don't go through accelerator programs, and most entrepreneurs don't raise millions of dollars, right? Most entrepreneurs either self-fund their businesses or raise money from folks that they know, friends and family or other investors that they may have met along the way. Those types of investors are usually perfectly able to and perfectly comfortable going into limited liability companies. So if that's how you're funding your business, either yourself, what they call bootstrapping, kind of, taking care of your business's expenses on your own, or raising from your sort of inner circle, folks an LLC is not going to be problematic generally from a capital raising, dollar raising perspective. So those are the three choices. All of them are easy to form. There's different documents associated with each of them outside of the document you file with the Secretary of State of Illinois if you're forming in Illinois. They all have their pluses and minuses, but again, C corporations and LLCs tend to be the most popular. I'll mention one other thing. So when you're deciding to form an entity, Your first decision is what Esther talked about. When should I form this thing? And I think we've talked about earlier is often the safest time to form an entity. Then we've talked about how do I do it? We talked about the simple filing with the Secretary of State. We talked about what type of entity, LLC, C corporation, S corporation. And finally, you have to decide which state you're going to form in. And we've sort of made reference to this throughout the talk up until now. Every state has a body of law which allows you to file in that state if you want to file in that state and form in that state. Where do entrepreneurs typically file? Well, generally, if you're operating in Illinois, if you're based in Illinois, Illinois is often a perfectly good choice. Illinois has a sophisticated body of law, and as I mentioned, Illinois makes it pretty easy in terms of filing with the Secretary of State. There are plenty of states where it's more challenging. There's more hoops to jump through to form an entity. So Illinois is one choice and often a perfectly good choice for your entity. You'll sometimes hear, if you're talking to other entrepreneurs or others who started businesses, you'll hear about Delaware, which is unusual, right? Delaware is not a big state. There's not a lot of companies that we know of that are based in Delaware and operating out of Delaware, yet Delaware is a very popular choice to form an entity. The reason is, there's any number of reasons, but Delaware many years ago sort of discovered that if they created this really sophisticated body of corporate law, that companies would feel comfortable forming there because the law would make it really clear how they would be able to operate and what their protections were. And companies many, many years ago, a century ago, started forming in Delaware because they had this really, really thorough statutory framework to govern the creation of businesses. And it's kind of just grown on itself as companies started to form. There are more companies formed there. And so fast forward to today, lots of companies and lots of investors. I mentioned if you were going to raise money from like big professional investors, they're comfortable with Delaware because they've seen so many companies form there that they sort of understand how the rules work there. So if that's what you were going to do, if you were going to raise big money or go through one of those accelerator programs, sometimes Delaware is a reasonable choice. There's added expense if you form in Delaware. There's certain things you have to do in that state that you have to pay money each year, and you might still be paying money in the state where you're based each year. But for most companies, if you're based in Illinois, you're operating in Illinois, Illinois is usually a perfectly reasonable choice. And that way you're only forming in one state. You don't have to worry necessarily, depending on if you expand, you might have to deal with other states. But if you're really focused on the Chicago area or Illinois, Illinois is usually a good choice. So an Illinois LLC, an Illinois C corporation, Illinois S corporation, depending on your circumstances, tends to work pretty well. So that's entities in a nutshell. I saw a couple questions come in. So the ones that I saw, I'll take. And then we want to open this up. We really would love to have all of your questions. We like answering questions. So don't be bashful. Ask them if you got them, and we'll do our best to answer them. So the two questions that I saw, one, I saw a question about a series LLC. So that's a good question. So a series LLC is relatively new. It's not all that new anymore. And the idea behind a series LLC, at least as when they were first formed, the way it was explained to me, think about if you owned like an apartment building. And so you formed an LLC to own that apartment building so that if something happened, there was liability somehow associated with the building, you'd be protected because you'd own that building in an LLC. Well, let's say things are going really well and you bought a second apartment building. Well, what people were doing is they were forming a different LLC for each apartment building. In case there was liability, somebody got hurt at an apartment building and you wanted that liability protection around yourselves, you'd have a different LLC. So you weren't mixing all the liabilities together in one LLC. You'd separate those liabilities out. So if a problem happened at one building, it couldn't affect the other buildings. Well, that was expensive. Every LLC you create and form costs money. And then there's annual maintenance fees with the state that you pay to maintain the LLC each year. And so the series LLC was invented for situations like that, where you're going to be operating sort of different business lines. I'm using apartment buildings as an example because that's how they sort of got their start. But it could be any type of business. If you were going to sell T-shirts and then you were going to provide consulting, let's say, an odd mix, but let's say you were going to do that, you could form a series LLC. And the T-shirt business would be within one series within this sort of parent LLC. And you'd have a second series to do the consulting work. And that way, if there was a problem with the consulting, it couldn't affect your T-shirt business and vice versa. Series LLCs, I mentioned forming an LLC tends to be easy. Series LLCs get a little trickier. They get a little more complicated in terms of the documentation to sort of separate out these businesses within the series LLC. It's a different filing with the Secretary of State. When you file, the Secretary of State asks you the question, do you want to form a standard LLC, which is what we've been talking about. And sort of the vast majority of limited liability companies are standard, regular limited liability companies. But if you were going to form a series LLC, you could check that box. And there's different information you would provide. And you'd probably want to work with legal counsel or advisors that have some familiarity with series LLCs to make sure that you're, crossing your T's and dotting your I's so that you get the benefit of setting up the different series within an LLC. So for most businesses, series LLCs probably not necessary, but something to evaluate if you're going to have sort of different businesses and you don't want to form a bunch of different entities. So that was one question.
Darren, I'll just jump in here because sometimes people ask about series LLCs and this may not be relevant to the question that was being asked, but sometimes people are wondering, can you have more than one sort of line of business or product within one company? And do you need to do a series LLC? And for that, the answer is no. So often our clients will have one LLC, but lots of, different products that they're offering or even, divisions, and you can do a lot within one entity. When you want to start thinking about having a separate entity is for a lot of the reasons Darren talked about. If you want to limit liability from one business so that it can't impact another business, then yes, having separate entities is important. Or if you have different ownership structures. So one line of business, you have certain owners, and a different line of business, you want to have separate investors or different owners. That could be a good reason for setting up an entity. But I always like to give the example of Procter & Gamble. Think about how many different brands they have. And as far as I know, it's one company. And lots of companies will have more than one brand or more than one division. And you can do, again, unless it's for liability perspectives or tax reasons or investor reasons, a lot of times it makes sense to do it all within one entity. I see also a question on not-for-profit. So I'm going to grab that one. So if you are setting up a not-for-profit, usually you're going to set up a not-for-profit corporation. So not an LLC, but a not-for-profit corporation in the state that that you want to set it up in. A lot of times we'll do an Illinois not-for-profit corporation. And like Darren said, with other types of entities, it's a very straightforward, fairly easy form. It's even less expensive. But then that's the entity. It's a not-for-profit corporation. But I think the question mentioned 501c3 status and tax exempt status. That's something different. So then that not-for-profit corporation has to apply to the IRS for tax exempt status or to be a 501c3. And that is by completing what we call a 1023 application. So many numbers. You complete a 1023 application with the IRS, and it's the not-for-profit corporation that's submitting that application. And they're basically applying, the not-for-profit corporation is applying to the IRS to fit under 501c3 of the tax code to be a tax exempt organization. And yes, there's lots of requirements. You have to have an exempt purpose. You have to put an addendum to your articles of the not-for-profit articles of incorporation, making certain agreements that comply with the requirements for getting 501c3 status, and assuming you are granted a determination letter that the not-for-profit corporation is sent a determination letter from the IRS that the corporation's a valid 501c3, then you get some of these benefits like you're tax exempt. You're not paying federal tax for any income that's related to the mission. and your donors can contribute money and take a tax deduction. So there's benefits to becoming a tax exempt organization or a 501c3, but it's the not-for-profit corporation that applies for that status. And I would say there's a longer form, a longer 1023 form, and there's also a shorter 1023 EZ form, and you can do it online. It's much simpler, but you have to be a smaller, your goals have to be a bit smaller. And I don't remember exactly what the numbers are, but it's having, raising less than $250,000, I believe, and having less than $50,000 in assets. And I might be off on those numbers, but it's agreeing that your goals are financially smaller. Otherwise, you have to do the full, much longer 1023 application.
So I see a question here, which I'll grab. Florida, a place I'd like to be right now with snow heading our way, but I won't be. Florida, it's sort of well known. There's no sort of state income taxes, right? There's certain tax benefits to being in Florida. So the question is, does it make sense to form in Florida? So a couple things. So one is, it's certainly possible to form there. Florida has laws around entities, just like Illinois and Delaware and other states do. So you certainly can, but you need to bear in mind, there's sort of two different payments. There's lots of different payments you make when you form an entity and you're running a business. And those of you that are running businesses are familiar with making payments all the time. So one set of payments is what you pay the Secretary of State when you form the entity, usually a couple $100s. And then every year you pay the Secretary of State some annual maintenance fee so that the entity lives on for the next year. You keep maintaining the entity by making an annual filing. So if you formed in Illinois, you'd make an annual filing. We're not Florida attorneys, but presumably most states have some sort of annual filing requirement. So that's one set of fees based on where you form. So if you form in Illinois or form in Florida. When we start talking about taxes, it's a little bit different. When you think about taxes, it really comes down to where the owners in the business are based. So let's say you form in Florida, but you're an Illinois business. You're based here. You've got an office here. You're hiring people here. Again, without giving tax advice, because we're not accountants, by and large, you're going to be paying some Illinois taxes. Whereas if you were based in Florida, you'd either not be paying taxes if they didn't have an income tax or be paying taxes. Where you form the entity usually isn't the determining factor in whether or not you owe income taxes or certain taxes on your profits in a given state. That's usually based on where the business is operating and sometimes where the owners are based and where the owners are located. So the answer is yes, you could form in Florida, but you'd want to talk to your accountant to sort of find out and confirm. Your accountant might say, you're not going to get any benefit by forming in Florida. You're going to owe the same taxes you would have because you're based in Illinois. And now you've got this entity in Florida. You might have separate filings with the Secretary of State of Illinois. It might become more expensive. It might be more efficient for you just to form in Illinois. There may not be any benefit to forming in Florida. So on that one, before you ever did it, you'd certainly want to check with your accountant as a starting point to see if there really is any benefit from a taxation standpoint. If there was, then you need to look into, okay, what does it mean to be an entity in Florida? Their laws are different than Illinois. So you need to sort of understand, is Florida a favorable place from an entity perspective? Are there certain quirks to being an entity there that create risk for me, right? And that's something a Florida attorney would be able to advise you on. So once you got past your accountant, if it still made sense to live in Florida, you'd want to talk to someone who's experienced, Florida legal counsel to sort of determine whether or not there's other things you need to know about forming in Florida. So hopefully that answers your question on Florida.
I'm going to take the next question on trademark. So someone asked, do you have to get a trademark protection on your company name? And it's a great question. You want to think about your company name and your trademark. Those are separate issues. So to get a company name, there's a lower standard. It just has to be in most states distinguishable from other company names. But to get trademark protection, it's a higher standard. To use that name as your brand, you can't infringe on anyone else's trademark rights. And you also have to pick a mark that's entitled to strong enough trademark protection. And the test for trademark infringement is the likelihood of consumer confusion. So you can make your company name, probably or pretty much whatever you want, as long as it's distinguishable from other names in the Secretary of State registry. But assuming it is, and then you have a company name, the next question is, can you use that company name as your trademark or as your brand? And again, they could be different, they could be the same, but assuming you want to use your company name as your brand, then for example, I had a company, Elazar LLC, and we wanted to use Elazar as our brand. So then I have to think about Elazar not just as a company name, but as a brand, how do I acquire trademark protection? So first I have to pick a mark that's strong enough for trademark protection in the first place. So we won't go into a whole lecture on trademark law, but the more unique the mark is, the more likely it is to be entitled to strong trademark protection. Generic words are not ever entitled to trademark protection, and marks that are merely descriptive, it takes longer. They're not entitled to immediate trademark protection. But assuming it's a unique enough mark to be entitled to trademark protection, then you want to think about whether someone else may already have rights in that mark, so that you could be infringing on an existing trademark right. And in that case, you're going to be doing some searches to see what else might already be out there. And then you're looking at the mark that's, it doesn't have to be exactly the same, but close enough that it would be confusing to someone, and in a related or similar enough industry that someone would be confused. And what you're looking at is, would someone be confused as to the source of that product or service? Assuming you feel pretty good about the mark being strong enough and not infringing on someone else's trademark rights, you can register that mark or apply to have that mark registered with the United States Patent and Trademark Office, again, provided that you're using that mark outside of just Illinois. Otherwise, you'd only be entitled to state trademark protection. And then you would get, assuming the mark gets registered, federal trademark protection, which is if you're a national business or intending to be a national business, having that federal trademark protection is important. I will say, just by using the mark in commerce, so just selling your product or service, you can potentially acquire common law trademark rights. So you can get rights just for using that mark, but those rights are really limited to just the geographic area that you are running your business and selling your product or service. It was a little bit of a longer answer to that question, but hopefully that was helpful.
So I see a question, sort of just kind of a mechanics question. So let's say you file and form an LLC in Illinois. I think here was October of 2021. I mentioned this annual report that you need to file. So the question is, when do you have to file this thing? Is it year end or is it some other time? And typically in Illinois, you're filing the annual report. So this is something you file every year. The Secretary of State will often notify you that a file is, not always, sometimes it doesn't find its way to you, but there's often a notice that comes around from your registered, it goes to your registered agent when you form the entity. But it's usually your anniversary month. So if you formed in October, you would typically file the annual report before that anniversary month. So you'd start thinking about it. You want to put in your calendar, maybe beginning of September. Remember to file Illinois annual report. Again, you can do this online. Illinois makes all of this very easy to file. So that's usually it. In other states, sometimes they do go by year-end anniversary. And so you've got to file, by December 31st or within the first 3 months of the year. But in Illinois, it's generally your anniversary month. So put it in your calendar somewhere where you'll see it and that you'll remember. You might get a notice and you might not get a notice, but you'll want to make sure to do that filing. If you don't do the filing, you do get some sort of warning. So usually there's a notice that you're late, and then there's a notice that you're really late, and there might be a late fee. You have to pay a little more. And if you keep doing nothing and you never file anything to maintain it, at some point, they'll send you a letter saying they've sort of administratively dissolved the entity, meaning they sort of assume you don't want the entity anymore. So they kind of dissolve the entity for you. At that point, if you wanted to kind of reinstate the entity or get it up and running, it would be sort of pricey. So you'd rather be current on your filings so you don't end up having to pay more money than you need to.
And we have a question about DBAs. DBAs tend to be used more when you have a sole proprietorship. So you want to have it's just you. So you want to be able to have a doing business as name that's other than your name. So then that's probably worth it. And there's some requirements to acquire a DBA. But generally with our clients, the DBA, you're generally doing business in your company name. So they're not as common, and more often than not, companies who want to use a particular name, it's for a branding purpose. So again, we're going back to trademark law for that rather than a DBA.
And I see a question here. What if you're part of a network marketing enterprise? Do you need to set up your own entity? Are you protected from liability by the company, or does it depend? You sort of anticipated the answer at the very end. It unfortunately always depends, right? So when you think about networking groups, so sometimes folks who have different jobs or have started different businesses will participate in some sort of networking group. And maybe they'll get together every month over coffee or breakfast, and they'll network with each other and share stories and contacts and try to help each other out. Those types of networking groups, usually you're not, if you're participating sort of on behalf of your company, you're usually not forming a separate entity for that. You're just getting together, you're just talking, you're not really forming a business with them. It wouldn't seem there'd be much in the way of liability exposure if you're just chatting and sharing names and recommendations and all of that. So in that regard, you probably usually wouldn't form an entity. You'd just be there as a person. But I suppose if it was something more formal that was going on, and you were sort of part of this group kind of on your own behalf, let's say you're not there on behalf of your business, but maybe you're thinking of starting a business and you're going to a networking group, and it's more than just networking. It's more than just having coffee and sharing stories and thoughts and contacts and recommendations, but you're actually doing things. Out in the community, or you're doing things where you could sort of think to yourself, maybe there could be liability. Somebody could get hurt with something that we're doing, or we're creating some sort of intellectual property that could be a problem down the road. In that case, okay, then maybe you would. Maybe you'd say, you know what, I'm going to show up on behalf of my entity rather than as a person. But that would be probably the exception rather than the rule. And most networking groups, and you asked the question, does the networking enterprise provide protection? Again, that depends. It depends on how formal the networking is. Is it like a membership thing where you sign a membership agreement? Maybe there's some protection there. If it's more informal, there's probably not. So you sort of need to look at how that networking enterprise is set up to determine whether they offer any liability protection. So that's one big long-winded way to say it depends, it depends, and it depends, and it depends. But hopefully that's at least somewhat helpful.
So we have a few questions on, can you switch from an LLC to a corporation? And the easy, quick answer is yes, that it's not. And to move from an LLC to a corporation, we have clients do that all the time. You probably want to work with a lawyer, but you can certainly convert an LLC to a corporation at a later date if your needs change and it makes more sense to be structured as a corporation. For us, we see it mostly when our clients set up as an LLC initially for tax reasons and for flexibility. And then as the business grows and they're closer to getting an investment from a sophisticated investor like a venture capital firm, and they need to be a C corporation, they'll convert from the LLC to the C corporation at that time. And yes, so it's very, very possible, and we see it all the time.
And I see a question here. Great questions by everyone. These are really spot on. If you form in one state, can you still do business in other states? That's a good question. So the answer is yes. So I mentioned Delaware, Delaware entities before during my talk. So all of those entities that are formed in Delaware, by and large, are doing business somewhere that's not Delaware. They're doing business maybe across the country, maybe in California, maybe in Illinois or some other state. So there's nothing that precludes you from forming in one state and doing business in one other state or 40 other states. But there's additional things you would keep in mind. So one, if you're, let's say I'm based in Illinois and I'm growing, things are going well. And so I decide to open a new branch, a new location in Michigan. So if I do that, I open a location in Michigan, I'm still formed in Illinois, but now I'm operating out of my Illinois location and I'm operating out of a Michigan location, both owned within the same entity. in that case, there's a process in each state. Sometimes it's called foreign registration. It's not really foreign. They mean foreign, a different state outside of that state. Sometimes it's called becoming authorized to do business. But there's a filing you make where you tell that new state, in this case, it would be Michigan. You'd say, look, I formed in Illinois, but I just opened a location here, a restaurant, let's say. I just opened a restaurant here too. I want to be able to operate here. I want to be able to operate in the state. If I need to use your court system for some reason, I want to be able to do that. There's a filing you make with the Secretary of State of Michigan. Usually those filings are available on the Secretary of State's website. And you would pay them a little bit of money and you describe your Illinois entity to them. And you'd say, I want to become authorized to do business here. They would stamp it in some way, they being the Secretary of State. And once you got that file stamped copy back, you're now what's known as being authorized to do business in Michigan, meaning you can operate there. There's certain benefits you get in each state by virtue of being authorized to do business there. It's always a question, when am I doing enough in another state that I have to take that step? Because once you become authorized to do business in a different state, not only are you paying an annual fee to Illinois, as we talked about with an annual report, there's usually an annual fee in that other state where you're authorized to do business. So it can get a little pricier. There are different tests in every state as to when you're doing enough business there that you need to become authorized to do business. There's a book that Esther and I both have about becoming authorized to do business. You could get that book, or you can sort of look with the Secretary of State to determine whether you're doing enough business that you have to take that step. But at a general level, the answer is yes. You can operate across the country so long as you keep your eye on becoming authorized to do business, and so long as you work with your accountant, because once you start generating income in other states or employing folks in other states, there may be certain local tax requirements that you need to take into account in terms of withholding and Social Security and the other things you need to do when you have employees. So you'd want to be aware of what to do on the tax front, and you'd want to keep your eye on whether or not you need to become authorized to do business.
So there's so many great questions, and we're never going to get to all of them. I'm going to answer one last one, but also someone asked about, do we have any links for trademark resources? I put in the chat a link to a video that Darren and I did for 1871, all about how to protect trademarks, how to search for trademarks, how to think about trademark law. So hopefully that would be helpful. It's kind of like the kind of workshop we just did today on entity selection, but it's all on trademarks. So enjoy that. The last question, a few people have asked about, do you need a lawyer to do all of this? And Darren had mentioned earlier that setting up these entities isn't all that difficult. A lot of people will use a lawyer, and certainly you can, and we always think it's a good idea to use a lawyer. But if you feel comfortable, it's not that difficult, and you can go on especially if you're doing it in Illinois, on the Secretary of State's website. There's actually a really great memo that walks through some of the issues to think about when you're setting up an entity. So just going onto the Secretary of State website, you may get comfortable enough that you feel comfortable filling out the documents and applying to set up the entity yourself. But again, it's also always great to work with a lawyer and make sure you get it done exactly the way you want. And also a lawyer may have some suggestions about the appropriate entity or the best entity selection for you. Did the link not go through? Can you please resend the trademark video? I don't see it. Does anybody see it? Because I see it.
So
Esther, try sending it to everyone instead of just a host and panelists.
Oh, did I do that? Oh, thank you. Okay, now I think I did it the right way. Zoom 101.
Keep learning new things every day.
And with that, unfortunately, I think we are out of time, but this has been, for us, so much fun. And again, your questions are really interesting, and we appreciate all of the questions that you asked. It makes it a lot more engaging for us.
Yeah, I'll echo that. Thank you very much. Fantastic questions. We always enjoy the questions. So best of luck with your respective business ventures, and we hope to see you out there.
Absolutely. Have a great
Thank you both so much. We really appreciate you taking your time out to present today. And again, the webinar will be posted at www.youtube.com/ChicagoBACP. Thank you, and everyone have a good night.
Terrific. Thanks, everyone. Thanks for
Bye.
including us.